बिस्मिल्लाहिर्रहमानिर्रहीम। अस्सलाम वालेकुम। कैसे हैं आप लोग? हेलो, कैन यू हियर मी?
हेलो, अस्सलाम वालेकुम मैम।
कैन यू हियर मी?
हेलो,
हेलो, अस्सलाम वालेकुम। कैन यू हियर मी?
वालेकुम अस्सलाम। Sorry ma'am, I think there's some problem.
ओके,
Yeah, how are you? I'm good.
गुड, नाइस टू सी यू किंजा। नाइस टू सी यू। ओके, सो हाउ आर यू? हाउ आर यू?
I'm good. Yeah, I'm good ma'am. How are you?
Good, alhamdulillah. I'm doing great, in fact. And did you read chapter 1?
Yes ma'am, I went through it, made some notes.
That's great. That's great. All right. So today we are going to start with chapter 2. Okay.
Okay.
So chapter 2, we have sources of law. We have done till now what is law, why law, and what is the structure of UK law. So today, what we are going to do, we are going to study what are the sources of law. That means what is the root of law? From where does this law come from? Where does this arise from? If anybody gets stuck in some law, either creating it or in implementing it, then where should he look to? Where should he look into? Where should he go to ask, to verify that is this law correct? Is this law correctly interpreted? Is this law correctly understood? Is this law correctly created? Is this law applicable in this particular case, in today's time, in this generation, in this particular type of case? So that's what we are going to do in this chapter. Okay, sources of law. So let's just go through it quickly. What are the topics? Case law and precedent, legislation, statutory interpretation, the European Convention of Human Rights, UK human rights law, and the impact of the Act. All right. First topic, case law and precedent. What is case law, Kinza? Till now, what understanding have you got about case law?
Case law is, I think it's the case, whatever the other person is confused about or the dispute is about.
Okay. As we have,
I don't know the exact terminology of this
okay,
case
no
law.
worries, no worries. We are here to learn together. In the previous chapter, I just explained this term pretty briefly, but in this chapter, we are going to go into details. We studied about common law and case law. So there's a difference between both. Common law, as you guys told me in the last class, that common law is common for everyone, right? Which should be followed by all. Okay. So common law which should be followed by all. And what about case law? What about case law? We did we went
I think it's for the specific organization, maybe for the specific category.
okay. Good try. Case law is basically a collection of cases. What is it? Case law is basically, oh my God, my pen is not working. Case law is basically a collection of cases. that have been solved since the beginning of the law system. Now, since the beginning means what? Since the beginning means you go back to the kings and the kingdoms and the knights and the wazirs who used to solve the cases. They used to come back to the palace, sit down, put their heads together, share the experiences, share the conclusions they gave, how they solved the conflicts, shared the judgments they passed, the punishments, the penalties, the damages, the equity. So all these things these knights gave, they they just wrote it down so that it helps them to study what different types of cases are coming forward, what different types of conflicts, so they can study and categorize them that okay, civil law, criminal law, right? How they came to this categorization? Somebody must have, collected all of these data,
Done it first.
studied it,
Yeah.
did research on it, thought of a structure, thought of a process, thought that okay, we are alive right now, we are the wise people, but what about the people who are going to come next, who are going to become the next kings or the future viziers or the future knights of the future lawmakers? So let us put down our study on in this book, in this particular place, so that it helps the future upcoming leaders as well. So they may study, take help from it, what kind of law, what kind of punishment, what type of conflicts, right? All of that. That is case. That is case.
Okay.
You can call it a collection of cases, you can call it a book, you can call whatever, but it is a detailed study where you can go to, you can refer to that what had been, has a similar case come in the past, and which judge was there,
Oh.
who passed the judgment, who looked into the matter, and what was the principle on the basis of which they passed the judgment? What was the principle? क्या झूठ बोलना इतना बड़ा गुनाह है कि जिसके लिए हाथ काट दिए जाएं? क्या कत्ल का बदला कत्ल है, जान का बदले जान, आंख के बदले आंख? So what is the underground or the basic principle upon which this judgment has been taken? Because see, cases will vary. Am I clear? Cases will vary. Cases will be different.
That's
Claimants
right.
will be different.
Yes, the situations, the scenarios, they will be different.
Each and everything will be different. Era will be different. We are in a digital
Yeah.
era. If you think about
That's right.
years back, it was not a digital era. Computers
Yeah.
had just, started coming out. So the things change, the laws change, maybe the principles change. The cases vary
But
from.
ma'am, when there's a new law, like for example, cybercrime, it was not there before. So when there's a new law, so do they put this in the case law book as well? Is it a book case law?
Definitely, they have a record. They do keep a record. That's how humanity learns. That's how humanity progresses. For example, if I gave you the first person who tried to make the flight, aeroplane, who were they?
Yeah.
Do you know them? The Wright brothers. Okay, the Wright brothers first invented the aeroplane, and their first flight was of 11 seconds only. 11 seconds flight. Do you think, had they not written down the formula of taking a flight, the science behind taking a flight, the science behind keeping the flight 11 seconds in the air, do you think the upcoming people would have been able
Definitely.
to invent more sophisticated and complicated air jets, rockets, fire jets? Do you think if the basic formula was,
Without that, no.
so they must have
No.
down somewhere, they must have shared their knowledge, right? How is it possible then that so many companies and industry come into existence without that basic scientific formula?
Yeah.
Same goes for Newton, the first apple that dropped. Everybody knew it that apples drop down, fruits come down, but nobody could, express it in words that this is because of law of gravity.
Yeah.
Newton could, and he did. Had he not, we would have never discovered this law of gravity.
That's right.
So he had expressed in some way, either in words or in writing. Then only that information passed around the globe. That is how it passes, right? Now, you
Yeah.
call case law a book, you call case law a file, you call case law anything, but it's a collection of cases where detailed cases have been discussed so that the upcoming judges, the upcoming lawmakers, the upcoming people who are giving justice to the society, they can study those, they can get down to the principal line underground beneath those decisions of those judges of those times, and so they can apply logically whatever is applicable in the current situation, in the current case.
Okay.
When we will be studying F4 law paper, you will find many things that, oh, okay, this is so easy, this is so interesting, fine. But when you go into the field, when you actually dive into the field of law, the court system and everything, and you actually hear the cases, then only you can realize the challenges that come to that judges have to face, that the lawmakers
That's
have
true.
to face, that the what are they called? वकील को क्या बोलते हैं, lawyers have to face,
Lawyers.
the claimants have to
Yeah.
face, the defendants have to face. So unless you go get into deep dive into this field, you won't know the complications, the challenges. We can just read, it's easier to read and say, and just to feel that okay, we have
Because
understood.
there is no right and wrong in it. If there's it's right and wrong, then they can just go to the computer, feed it that if this person has done this, this is the punishment. There is no right and wrong. We have to just think over it, that where this category lies and how do we need to decide it.
Exactly, there is, in life it's not black and white, there is something called,
Yeah, that's right.
there are
Gray areas. Yeah.
all right. So coming back to the text, common case law and precedent. Now see, what is common law? Common law is a broad category. Okay, common law is a broad category, and so is case law. They are somehow or the other overlapping each other. Okay, so let's first read what case law is, then we will get to the common law. Yes, start reading.
Okay. The first legal source of law consists of decision made in the courts is case law, which is judge-made law based on the underlying principle of consistency. Once a legal principle is decided by an appropriate court, it is a usual precedent. Okay, when the judge has the legal, I think when the judge has made the decision, so all the other judiciary will also look into it. I mean, they will follow the other formalities. Is it what they mean?
Yes, so what did you understand? Ali, are you there? Can you explain? There is internet problem. Is it getting disconnected? Getting disconnected on my side. Yes, can you hear me, guys?
Yes, ma'am, I can hear you.
Okay. Yes, so what did you understand? Ali, can you hear me? Can you explain this para? Ali Hassan, are you there?
And now I can hear you.
All right. Ali Hassan, please explain the case law, this para which Kinza just read. I can't hear you, Ali. Okay, Kinza, can you explain?
Well, I think, ma'am, whenever there's a case coming up, so first they look into which category they underlie, like they look into the case law, and then later the judges decide whatever the right decision is. They just think over it.
As we discussed, the first legal source of law. First legal source of law means what? That the first place any person who is having difficulty in understanding the law or interpreting the law or making the law. Okay, where will he look into? Where will he look into? He will look into the case law. He will refer to the case law, that what does the case law says? What does this book say? Does this book has any case which is similar to my case? Now, what are they saying? That case law, which is judge-made law. Okay, judge-made law. Case law is a book. It's a book that has been collecting the cases down the line from the kings and the queens and the first time the law got initiated. So over there, the law was being made directly by the king or the judge or by the person who had the authority. Okay, and the wisdom. So judge-made laws are in that book, and they have an underlying principle of consistency. What does this mean? Like, ऐसे ही
That
नहीं
they are consistent, they're not changing.
ऐसे ही नहीं कि मेरा दिल चाह रहा है और मैंने एक कानून बना दिया कि भाई हर कोई सुबह 6 बजे उठेगा और सुबह 6 बजे अगर जो नहीं उठा उस पर मैं पेनल्टी करूंगा या करूंगी. ऐसे ही अलल टप कुछ भी लॉ नहीं बना देना. There has to be
There
some
should be a logic behind it. Yeah.
behind it. And that principle is not like that कि आज का principle है कि भाई law of gravity होती है और कल का principle बन गया कि law of gravity नहीं होती. You can't change it. Law means law. You cannot change it. As the physics
Yeah.
law, as the law of gravity, as any law of nature, it is as consistent and as stubborn and as still as law of nature. You can't change it. वो कहते हैं ना that जो बोगे वही काटोगे. It is a law of nature. What you sow, so shall you reap. You can't change it. Whether you accept it or you deny it, whether you like it or you don't like it, whether you work according to it or you go against it, it is there and the world is operating that way. बड़ा मजे का जुमला है. तो कहते हैं कि आप यहाँ नेकी करते हो या बुराई करते हो. इसकी एक नेचर है. वो नेकी या बुराई भाग के चौराहे पे जाके खड़े हो जाती है और आप ही का इंतजार करती है. और जो आप चल के उस चौराहे तक पहुंचते हो वो आपको रिटर्न मिल जाती है, चाहे नेकी हो चाहे बुराई हो, जो भी आपने खोया. That's the principle. Now we have to refer if we are stuck in making the law, in creating the law, in interpreting it, in applying it. Anywhere if we get stuck, we refer, we go back to the case law, we check out the principle, and then we try to apply or pass the judgment or use it, keeping in mind that what was the principle behind creating this law, or what was the principle behind this particular judgment passed by the judge. Am I clear till here?
Yes, ma'am.
All right. Ali Hassan, you're disconnecting again and again. Are you able to follow?
Ma'am, he's not here.
He's not here, but I can see him here. He's joining. His network is not
Okay.
some problem from his side. Okay. Now, moving ahead, one principle. Once a legal principle is decided by an appropriate court, it is judicial precedent. What is it? Judicial precedent. Now, what is a judicial precedent, Kinza?
It is like a stamp that it has been decided now by the judicial precedent.
Exactly.
Maybe it's a designation.
देखो कोई तो होगा ना जिसने इनिशिएटिव लिया होगा, जिसने ये कानून बनाया होगा कि स्मगलिंग जो है एक क्राइम क्रिमिनल एक्टिविटी है, जिसने ये कानून बनाया होगा कि भाई कत्ल करना एक क्रिमिनल एक्टिविटी में फॉल करता है. किसी ने तो ये बनाया होगा ना. तो जिसने भी ये बनाया, he must be an authority. It has to be a court or a judge or someone who has that authority at that period of time when he created it. So whoever creates it, whether it is, you know, in our country, like in Pakistan, it is the parliament that is creating the law. Okay. So the parliament passes a bill that, okay, this is the problem the society is facing. So what law will we need to create in order to address this problem? So they are creating the laws. So once the law has been created, the legal principle lying beneath it has been decided upon. That particular thing is called judicial precedent. What is it called, Kinza? Judicial precedent.
Judicial precedent.
Precedent. Judicial precedent. Okay. Common law and equity. What is common law? Please read. Ali, are you there? Are you connected now? Full and final. You're mute. Ali, I'm talking to you. You're mute. Yes, Ali. What is happening on your side? You're disconnecting again and again. Is everything all right?
I am at hospital and like there is a signal issue. Now it's fine.
Okay. I hope you stay connected so that you can follow the course. Okay. Right. Common law. Kinza, please read.
Shall I read?
Ali, Ali, read.
I can hear you. Shall I read?
Go ahead, Ali.
Uh, the earliest element of the system developed was the common law, a system incorporating rigid rules applied by royal court, often harsh consequences. Equity was developed 200 or 300 years later as a system of law applied by Lord Chancellor in situations where justice did not appear to be done under the common law principles.
Okay. What did you understand? What is common law? What is equity?
Basically, it is the set of rules that are rigid and that are fixed for all common people.
All right. Number one, it is rigid. Rigid means it is fixed, right? It's not changeable. Like आपको red light cross करने की इजाजत है लेकिन किसी और को नहीं. No. If red light means stop, red light means stop for all. If yellow light means ready, it means ready for all. If green light means go, it's go for all. So it's rigid and it's applicable for all. Okay. And what is equity?
Uh, Common law is the body of legal rules common to the whole country, which is important in judicial decisions. Equity is a term which applies to the specific set of legal principles which are developed by the Court of Chancery of Supplement, but not replace the common law. It is based on the dealings between the parties. It added to and improved on the common law by introducing the concept of fairness.
Okay, Ali, what did you understand by this term equity?
Basically, equity is the term. Hang on a second. Equity is also a rules of set, but it is not replaceable unless some new law is introduced via the concept of fairness by the other judicial systems.
Okay. All right, so make this clear, make this very much clear that common law and equity. Common law is like a big category and it's a set of laws which is applicable for all, okay, and which is common and rigid for all. Full stop. Now there is something under the common law which is known as equity. Like we studied in the last chapter, the difference between damages and equity. What is a damage, Ali? What is a damage?
Means any, you can say, any like you can say merit.
Kinza?
Ma'am,
Damage.
any financial loss.
Okay, it's a monetary remedy. What is it? A
Monetary
monetary
remedy.
remedy. It's a remedy which is given to the claimant or which is given to the victim in terms of monetary or in terms of anything which is equivalence, which has an equivalence to monetary. Yeah, a damage is a compensation in terms of monetary. It is a compensation or remedy which is given to another person, to the claimant or to the victim who has been harmed or who has been wronged or who has been injured. But anything which is of monetary equivalency or which has the equivalency of money is given, or money itself is given. Is it clear? Make sense?
Yes, ma'am.
So when we were studying damage, we also studied what is equity. In contrast to damage, what does equity do? Kinza, any input?
Question, ma'am?
Question is this, that in contrast to damage, what does an equity do?
Ma'am, equity is the loss which cannot be given. If it's a death, then obviously nobody needs equity.
Confused a bit.
All right. Equity is any remedy. Let's keep it simple. Let's keep it simple. Okay. Both of you, Kinza and Ali, listen to me carefully. It's important. These two terms are important. You must have a clear idea about these two. There is a case. In a case, there are two parties. Party A, party B. Party A is the claimant. Party B is the defendant. Claimant blames the party B and he says that my goats were stolen and you stole my goats, Mr. B. Mr. B is saying that no, I did not steal these goats. You're blaming me. What's the evidence? Mr. A says, I know you have stolen them. It is you. You were the one keeping an eye on my goats. You were the one last night asking me about the goats. You were the one spying on my goats. It is you. He says, no. Okay. Now what's happening? I am the judge, or I am the one who is going to resolve the conflict. So I tell, okay, I listen to A, I listen to B. Tell both of them, each of you bring your evidences. I look at the evidences. Then I ask the witnesses, the society, the people around, the family, the relatives, the workers, and then I come to a conclusion that okay, it was party B who is responsible for stealing the goats. So what punishment can I give to party B? I will say, party B, you have to either return the goat to A or give money equivalency to the goat. Because if you have killed the goat and you have eaten it up, then you give the monetary value of the goat to party A so that he can purchase another goat for himself. Either of the two, fair enough? Is my decision fair enough?
One more example.
Kinza, is my decision fair enough for party A and party B? I am giving party B two options. Either you get him his goat back or you give him the money.
Yes, ma'am.
By
It's
the goat.
right.
So what am I giving party B? Am I giving party B
Damage.
damage? I'm asking party B to give the damages to party A.
Yeah.
So what is a damage? Monetary remedy. What is a damage?
Monetary remedy.
What is a damage?
Monetary remedy.
Exactly, monetary remedy. Opposite to damage, in contrast to damage, there is equity. Like, for example, another case. Party A, an old woman. Party B, a young man. This old woman is blaming this young man that you killed my son. And this party B, this young man, is also this woman's son. She has two sons. One killed the other. Now, she is asking me that, O king, O judge, O court, give me justice. I have young grandchildren whose father has been killed by this evil man. I need justice. What should I give her to satisfy her, to, give her justice? As a judge, what should I do? Number one, first I will listen to her story, her side story. Then I will listen to his story. Then I will ask both of them, get your evidences. Then I will confirm from the family, the society, and the people around them. Then what will I do? Keeping in mind all the evidences, looking at all the evidences, looking at all the facts and figures, looking at all the statements given by party A, party B, the XYZ family, XYZ friend, XYZ society, and then keeping in mind the laws, keeping in mind the things that have been stated by the court, that how you can give justice. Would it be fair if I ask this young man to give a just handsome amount of money to the woman as a compensation? Will it be enough?
No, not at all.
It won't be enough. Why?
No.
Why it won't be enough? होने वाली बात थी.
Because there is a lot of
because-
like emotional
Yeah, because the money can't replace, these things.
Right, because if I as a judge, if I tell this man that
not be
give $1,000 to this woman, what do you think this woman will do? That she will shout, she will scream, she will say, "Can these $1,000 bring back my dead son? Can this money bring it back to me? Can this limited amount of money, $1,000, bring back the father of these two children who have been orphaned?" No, she won't be happy. She won't be satisfied. She will fight. She will definitely fight. And then what should I do? As a judge, as a king, as a person who is going to solve the conflict, who has to solve the conflict, what can I do? Can I bring her dead son back? What does she want from me? Dead son? Can I bring any dead human back to life? Is it possible?
No.
So then what should be done? What's your solution?
I think to give punishment to the other one so that at least he can have some peace.
Okay. But do you think a mother will just keep yourself in the position of that old woman? She has two sons, one kills the other. What is she supposed to do? She has young grandchildren. What is she supposed to do? Right? Now, the judge, no matter what judgment he will pass as per his perception, knowledge, understanding, it might not be acceptable by that old woman. She might not be satisfied anyhow, whether I give her damages or whether I give her an equity solution of my own understanding. Like you just said, that punish him,
Yeah.
send him to jail or hang him. This might also not be acceptable to that old woman. Is it possible?
That's right, but then why is she coming to the judge? If she doesn't want any revenge from her son, then definitely why is she coming there?
Now the point is, she does not want the type of judgment I want to give her, or I want to give her a justice in some way, in one manner, but she wants something else. It may happen that she might want that, okay, I want you as a court to give order to my other son to work hard and take the responsibility of the children his brother has left behind.
Ma'am, is it possible that we just set up our own rules and principle and we tell it to the judge that what do we want you to do?
That's the scene.
Yes.
That is equity. That is equity.
Okay.
That is what equity does, where our rigid principles, our rigid systems, our rigid laws, our ways of compensating someone is not acceptable to the claimant. He might suggest, and if that is lawful and legal, the court may agree to do that, to get that kind of settlement.
Okay. Okay.
That there where comes equity in. It shows some kind of flexibility.
Okay.
Okay.
Now got it. Yeah.
Next.
Ma'am.
Ali, clear?
Yes, ma'am. Finally.
Alhamdulillah. Now moving ahead.
Good.
Moving ahead, interaction of equity and common law produced three major changes. That means now there is a common law, rigid rules, rigid laws applicable for all, and there is equity where things are made slightly flexible for the people to keep them satisfied, to make sure they get justice, and they feel that yes, they have been heard, their issues have been resolved, and the conflicts have been addressed. So there were three major changes that came into existence. Ali, read, what were those three?
New rights. Equity recognized rights for which the common law gave no safeguard. A B. Better procedure. Equity may be effective than law in resolving a disputed matter. C. Better remedies. Definite common law remedy for the successful claimant was the award of the damages for their loss. The Lord Chancellor developed remedies courts. Equity was able to make the following orders. Defendant must do what agreed to do. The defendant must abstain from the wrongdoing, restoration of pre-contract status quo, and alteration to a document party intention.
Okay, so what are they trying to say? So what do you think?
Are the uh, thing which you explain us in another other words, I guess.
Okay, the first change, the new rights. न्यू राइट्स आ जाएंगे, न्यू सेफगार्ड्स, ठीक है, जो कॉमन लॉ शायद प्रोवाइड नहीं कर रहा या कहीं चूक रहा है तो वहां इक्विटी फिलअप करेगी. न्यू राइट्स. नेक्स्ट, better procedures. Equity may be more effective than common law in resolving a disputed matter. Why? Can you tell me why?
Because it cannot all the rules and all the options, all the ideas that could come into the uh, come and reflect into the present scenario. So scenarios can be varied, and upon that the judgment and the ideas could vary as per the claimant and the defendant sides as well. So maybe a better option can be given by the claimant.
Right, Abhi. Kinza, what's your input? Why equity is more effective than common law?
Because a common law is just thinking about the history and one way only. But now if we talk about equity, there are some different scenarios and different reasoning and different thinking is coming in. So maybe the equity is more effective.
Okay, come on. 100 बात की एक बात. Customer खुश, सब खुश. Yes or no?
True that.
100 बात की एक बात. The client is happy with the justice, everything is fine. So equity is doing that only. Equity is giving that person the justice he requires, not in terms of money, not in terms what the judge thinks is the best. Getting the point. That's why equity is more effective than common law. Because common law says, okay, चोरी की हाथ काट दो, खत्म बात. रेड लाइट तोड़ी, ट्रैफिक रूल्स ब्रेक किए, 1000 रुपए चलान. No ifs, no buts. Right? But what is equity?
Right.
What is equity? Accident हो गया. For example, there's an accident. Let's talk about it. Party A, party B. Party A is in the car and there is an accident. Okay. Party B loses or injures his leg. Who will go to the court?
Party B.
Party B will go to the court. He's the claimant. Do you
Yeah.
think money? And do you think will he might be only satisfied by money, by damage?
No, ma'am.
It is possible that he might be satisfied with damage. It is possible because there are different clients, different people think differently. It is possible that he might get happy with the thing that okay, $1,000 should be paid to the claimant by A. He might be happy with this. He might be perfectly fine with it. If he's fine by it, good enough. If he's not fine by it, he's saying no, give me justice, and he is blaming the driver that he was drunk and he was, driving the car in a drunk condition. So I just don't want money. I want something more. I want justice to happen.
Yeah.
So now what will happen?
Yeah.
Matter will be investigated. A will be looked into like, okay, was he actually drunk or not? Because he is saying so. So was that driver actually drunk? What is the evidence? Once the evidence is found, they might either say that, okay, we cancel your license or we suspend your license because you were careless while driving. You did not take the responsibility of keeping yourself in good state of mind before taking the driver's seat. Moreover, there was a loss of another individual. So his license can be penalized. But we might not be satisfied then also. He might say that, no, you have penalized his license, that's okay, but I want something more. And he might ask for that, I've lost my leg, for God damn sake, from where will I buy the leg? And the B might say that I want an artificial leg surgery to be done, which is very expensive. I cannot afford it. I want him to finance that.
Yeah.
Fair enough?
Yes.
Fair enough. If he was, driver A was drunk and the evidences are all against him, and if he is proven guilty, the court might go with the solution B wants. Okay? And A cannot
Okay,
deny.
ma'am.
A cannot deny because it's the order from the court. Now, I can understand it's difficult to imagine in the scenario of Pakistan because we live here, right? But it is easy to imagine when you go outside because
Exactly.
there are
That's
human
right.
rights, there are the citizen rights. They have the right to sue even if they purchase an expired yogurt from the shop. They can sue the shopkeeper. They can shut the shop down. Like strict actions can be taken, right? So that is where
Right.
equity comes in, and that is why equity is more considered to be more effective than common law. Better remedies. Better remedies, of course, equity has more options, variety. Equity is customized kind of, justice. So better remedies. And better remedies because of one, if just I want to state this or sum up this all up in one statement, it is customer is always right and you have to keep the client happy. If the client is happy and satisfied with the justice you gave him, then you are done. If he is not happy, then you know and client is happy does
There's no
not mean
use.
that you keep the wrong clients happy because your client is also the defendant, right? Or the
Yeah.
prosecutor or the prosecution. All are your clients. The criminal can be a client as well, but you have to keep the right client happy, right?
Yeah.
Okay, so next moving on to some terms which we will be looking into. Kinza, please read from here.
That the defendant must do what they had agreed to do, specific performance.
Okay,
That the defendant must
one by one. Equity was able to make following orders. Now, what does equity has? Equity has a special authority to give the following orders, which have been given special names. Okay, and order number one. What is order number one? Defendant must do what they had agreed to do. Where can this statement fit? In the scenario where there is a contract between two parties. Okay, and there's a contract between two parties. For example, you're a student, I'm a teacher, we have a contract that this course I will be teaching you for this period of time and this will be the timing. Somehow it is possible I may not be able to fulfill the contract. And rather excusing myself from you, from the students, what I do, I switch off my phone. I don't respond to you. I escape from giving a valid reason. I refuse to refund. I refuse to inform. What will you do as a student? You are having a problem. You're stuck. Your money is blocked. Your time is getting wasted. What will you do? You will go to the court, of course, right? Will you or will you not?
Not practically, not, but in imagination.
Pakistan, not in Karachi. Yes, because we don't have those facilities, unfortunately. But inshallah, we will be having them. हम देखेंगे, कभी तो देखेंगे. So, what will you do? You will go to the court in the first place. Which court will you go to first? What's the name of the court?
Magistrate court.
Magistrate court. You will go there.
Yeah.
You will take your issue there. You will ask them for justice, and let's see what solution they come up with. But one of the solutions or one of the orders that a court can pass under the umbrella of equity is of specific performance. The court can force me as a teacher that, okay, you had a contract with so-and-so student, you entered into the contract yourself consciously, and you are not retarded, you are an adult, and you are with an organization, perform your duties. So that order is known as specific performance order. Clear? Is this clear for specific performance?
Yes, ma'am.
All right. The second, Ali, read the second order.
The defendant must abstain from the wrongdoing. Injunction.
The defendant must abstain from wrongdoing. What case can you think of in this situation?
For example, if court asks you to retake the classes and you like teach in a right way, that could be.
Okay, maybe as a teacher, I am because I was trying to breach the contract, and you went to the running to the court like a little child crying over and complaining, and then the court told me that specific performance order. It gave me specific performance order. Now I am having that inside my heart some kind of hatred for you guys, that why you guys went crying. My phone was off just for 2 days, it got stolen or it was broke, that's why I wasn't responding. Why did you guys run to the court? You should have waited for at least a week. And you know, I have so many things in my heart for you guys. So what I start doing, I start insulting you guys in the class. I start leg pulling you, I start taunting you, I start, you know, creating small or big problems for you. I start being a tough teacher for you guys, a difficult one, right? So now what will you do?
Yeah.
Again, like a crybaby, you will go running to the court. Oh, see what my teacher is doing. Oh, look at them. And then what will the court do? The court will say, okay, yes, you, teacher, Mr. Teacher or Miss Teacher, come on, behave properly. Behave properly. Stop doing this. Stop harassing. Stop bullying. Injunction. Injunction. Now, this is a very small example which I gave so that it is easy to relate, but you can take it to bigger cases as well. Abstain from wrongdoing. Okay, I've got to know that you're about to get into a contract which is illegal and which is a crime. I got my inside information. So either you stop it right away, or you will have to face the consequences. It can be a warning from the court, right? So that is injunction. Is it clear?
Okay.
The word injunction?
Yes, ma'am.
Okay, so now next. Kinza.
Alteration of a document to reflect the party's true intentions. Rectification.
Hmm. How can you explain this? What if
This happens a lot in accounts departments. Like there are a lot of loopholes when we have some partnership, or when we have some bribe maybe, or some other intentions. What we do, we just make changes, alter up the document, and through that document, the intentions of the other our client or whoever we are in favor with, the main person cannot recognize what the real problem is in the accounts, or maybe in these kind of a stuff. So I guess that's the
Ali?
Yes, ma'am. Rectification basically, example, what came come to my mind is like two things. One example, if someone has damaged my home roof, so one example should be the court orders them to like renovate my roof. One example is coming this, and then another one example is like if make a contract to someone and they changes wordings or the clarification in the documents. So
That's
I think that
okay. Kinza and Ali, both of your examples are valid. Okay. Alteration of a document, it is what it is, what you understood, that you are presenting a document as a contract to your customer or client, and somehow or the other he feels that there is something wrong with the contract, or they are playing with the words, there is double meaning to the contract, or they are hiding some of the true intentions, and they go to the court and ask for their expertise, or that what should be done in this, because when you see, number one, for petty matters, nobody is going to go to the court. Do you agree? If you have a good system of court, for petty matters, you might go to a magistrate court, because magistrate court is easy, accessible, and there might be only one person, less hectic, okay? Or you might even go to a smaller council, okay, where they address the people's problem. You might even go to even smaller setup to your community center. You have a small community, a small town area,
yeah.
like you live in Beria town, for example. Then over there you have a small community center to address these day-to-day petty issues. Like plumber के साथ ये मसला हो गया, electrician के साथ ये फटा हो गया, फलाना चीज नहीं सुनना, ठीक है. But what about the big matters? The big matters where property purchases is involved, where vehicle purchase is involved, where mortgage is involved, where big business partnerships or big business, what do you call it, acquisitions are, you need to acquire a big business. So there's big thing involved. So you need contracts, big contracts. You're taking loan from the bank. You're taking insurance policy. There is a contract. And if you're reading the contract and you feel that there's something wrong, there's something fishy, or maybe they are playing with the words, you will definitely refer to, or you will take a suggestion from, you will consult an expert or a lawyer, and you will show the contract to them, and you will ask them what is it, like what will be the legality, and what will be the consequence if I sign it, if I enter into it. So if there is something wrong in it, the court has this power, has this authority, it can give orders to rectify that contract. Okay.
Okay.
to my mind, ma'am.
It's called rectification. Fourth, Ali, read. What's the fourth point?
Correct status quo, recession.
Restoration of the pre-contract status quo, recession. Any idea?
Like we have made a contract before, but now we need to change it. People are changing the contracts. They are not agreeing to what they did before, or they're not following the rules what they set up previously.
Yes. Okay. Any example, Ali?
For example, a tenant is living with the like landlord, and they had made a contract that if like you The tenant must inform the landlord before leaving the house prior 30 days, and they don't do I'm not explaining it right well. For example, the refund policy, you can say the refund policy. If someone claims it and uh, they say it valid up to the days, and then again they don't like refund that into the given time. I'm not getting it.
Okay. Restoration, restoration, restoration. दोबारा से अपनी जगह पे लेकर आना किसी चीज को। एक चीज यहाँ पे मौजूद थी, उसे किसी वजह से हटा दिया गया, धक्का दे दिया गया, किसी ने जबरदस्ती निकाल दिया, एंड what the court is doing, restoring that person or that thing in its place. Restoration. Is the
Clear.
clear? Restoration.
Yes, ma'am.
Pre-contract. Pre-contract. Pre-contract यानी कि कॉन्ट्रैक्ट होने से पहले, प्री-कॉन्ट्रैक्ट कॉन्ट्रैक्ट होने से पहले। स्टेटस को, स्टेटस को मीन्स उनकी स्टेट, उनकी सिचुएशन, उनका रुतबा, उनका मकाम, स्टेटस को, उनकी रेपुटेशन। Now over here, the case which I will give you is an example in a scenario of employer and employee. There is an employer, he is party A, and here is an employee, party B. Employer says that you did fraud. Employee said, no, 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 I didn't do it. What's the evidence? I am kicking you out of the job. You're fired. Employee has to leave. But the employee is innocent. Employee is innocent. He knows. What will he do? What will he do? He will go to the court. Right? He will go to the court, knock the door, that I have been wrongly dismissed. I am innocent. I have been blamed, and I have been kicked out of my job. It's not my fault. I didn't do anything. Then there is no evidence. And I was fired from the job in front of everybody. And I was being claimed for theft, fraud. Like, it's a big thing on my credibility. No other company is going to give me the job. I'm innocent. I have to prove my credibility. Court, please help me. So the court will ask for evidence, and he will bring the evidence he has. Then the court will call the employer that you come, you give your evidence. How can you, blame him or call him a thief without evidence in front of everybody? And you have fired him as well. Without any evidence, you have to bring the evidence to prove that what you did is justified. So now if the employer is unable to bring any valid reason, any valid evidence, what will the court do? The court will restore the pre-contract status quo, and that is called rescission.
Okay.
Are you getting it? Makes sense?
Yes, ma'am. Now getting it.
Rescission, rescission, that means contract से पहले जो इस employee की इज्जत थी, मकाम था, पोस्ट थी, वो सब कोर्ट इसको हुक्म देगी कि तुमने नाजायज तरीके से इसको निकाला, अब इसको तुम इज्जत के साथ लेकर जाओ ऑफिस में, सबके सामने सॉरी करो, इसकी वापस जो तुमने इसको इतना जलील किया इसको वापस वो एड्रेस करो, उसको दो, और अगर एम्प्लॉय अग्री करता है तो वो यही काम करेगा, अगर एम्प्लॉय अग्री नहीं करता है, एम्प्लॉय बोलते हैं नहीं मुझे कोई और डिपार्टमेंट में कोई और ब्रांच में नौकरी चाहिए, मैं इस बॉस के अंडर काम नहीं करूंगा, तो उसको वो दिया जाएगा जो वो चाहता है। ठीक है, अगर वो इनोसेंट प्रूफ हो गया तो। So this order is called rescission. Next, Important, very important statement. Where equitable rules, conflict, where equitable rules conflict with common law, then equitable rules will prevail. Follow me, read after me loudly. Where equitable rules
Where equitable rules
conflict with common law,
conflict with common law,
then
equitable
rules will prevail.
rules will prevail.
अब क्या हो रहा है? Equitable rules, common law, दोनों का फड्डा. Equitable rules कह रहे हैं कि भाई एम्प्लॉय बेकसूर है, एम्प्लॉय को अगर वहाँ उस बॉस के अंडर जॉब नहीं करनी तो उसको कहीं और जॉब दी जाए उसी कंपनी में. Equitable rules ये कह रहे हैं. कॉमन लॉ कह रहे हैं नहीं, कॉन्ट्रैक्ट के मुताबिक चलो. कॉमन लॉ कह रहे हैं नहीं, कॉन्ट्रैक्ट के मुताबिक चलो. एम्प्लॉय का एम्प्लॉयर के साथ कॉन्ट्रैक्ट साइन हुआ है, 2 साल तक उसको काम करना है उसी डिपार्टमेंट में, उसी पोस्ट में, उसी के अंडर और उसी सैलरी पे. अब ये दोनों टकरा रहे हैं आपस में, कॉन्फ्लिक्ट हो रहे हैं या नहीं हो रहे?
यस मैम, हो रहे हैं.
Equitable rule is saying, listen to the claimant. He is the victim. He has been unjustly fired from the job. He has been blamed to be guilty, to be fraud. Restore his pre-contract status quo. Restore his pre-contract status quo. There is a rescission order which you can give. Common law is saying no. Follow the contract. You cannot breach the contract. Who will win? Who will win? Come on, tell me who will win?
Equitable rules.
Equitable rule will prevail. Right? Ali, clear? Kinza, clear?
Okay.
Can't hear you. So gaye kya?
No, ma'am. Actually, there's some internet problem.
My
Hello?
is cracking. Okay. Is it clear? Is this statement clear?
Yes, ma'am. It's clear.
Okay. Moving ahead. ये हो गया आपका important statement. Rule. It's a rule. You cannot change it. Right. Now. और क्या किया आप लोग ने कल सारा दिन? Yesterday was a beautiful day.
Ma'am, I had some important meeting call, so I was there throughout the day. So
you run quite busy.
didn't enjoy the weather much.
Okay, great. Ali, what's your daily routine?
I wake up around 10 to 10:30, and then I just do the home chores and then bring my nephew home and then study, and then in the evening I go to job and then sleep.
Great. Okay, can you guys just stand up? थोड़ा सा उठते हैं, एक एक्सरसाइज करते हैं. Just stand. Okay. I want to see you if you guys can open your camera. खड़े हो जाए अपनी जगह पे. Okay. So the exercise is such that you have to think about a situation where you get stressed out or that is bothering you, or maybe you're angry about some situation. Okay, think of that situation and start tapping your right hand side. This, can you see? Start tapping it. Okay, think of that situation. Think of that stressful situation, that one situation where you get stressed out or you are angry about. Imagine yourself in that state of mind. And from 0 to 10, 0 to 10, give yourself a number. Give yourself a number where you can, where that number is demonstrating the level of stress you're having. 10 being the highest. 0 से 10 तक कोई एक नंबर चूज करें कि इस वक्त उस सिचुएशन को सोचते हुए आपका स्ट्रेस लेवल कहाँ है, या जब भी वो सिचुएशन आती है तो आपका स्ट्रेस लेवल कौन से नंबर पे होता है, या आपका गुस्सा किस नंबर पे होता है, आपकी फ्रस्ट्रेशन किस नंबर पे है 0 to 10 में से। सोच लिया? सोच लिया, नंबर चूज कर लिया? किंजा, अली, can you guys hear me?
Number is chosen.
All right, now you have chosen the number, you're thinking about that stressful situation. Start tapping this side of your hand. Start tapping this side of your hand. Okay, keep tapping it, keep tapping it, and now repeat after me. Repeat after me. I know this stress is too much for me.
I know this stress is too much for me.
I know this stress is too much for me, and I want to let it go right now.
And I want to let it go right now.
Now start tapping over here. Here where your hair ends of your eyebrows. Start tapping over here. Think of the situation. You can keep your eyes closed. You can keep your eyes open. It's up to you. Think of the stressful situation, the frustrated situation, where you are stuck. I know this situation is giving me a lot of stress. Repeat after me. I know this situation is giving me a lot of stress.
I know this situation is giving a lot of stress.
This situation is giving me a lot of stress.
And I'm ready to relax.
I'm ready to relax.
Now start tapping over here, just beside your eyes. I can feel the anger right now. Repeat after me. I can feel the anger right now.
I can feel the anger right now.
I know I am right and the other person is wrong.
The other person is wrong.
And I am ready to forgive.
And
ready
that
to
I'm
forgive.
ready to forgive.
Now start tapping under your eyes. I know these feelings of frustration come back again and again.
I know these feelings of frustration come back again and again.
And I'm ready to let it go right now.
I'm ready to let it go right now.
Now start tapping under your collarbone. No, over here. Between your lips and your nose. Start tapping. I'm ready to relax. Repeat after me.
I'm ready to relax.
Start tapping over here. I had a busy day, I know. I know I'm all busy. And I'm ready to let go and relax deeper. Start tapping under your collarbone. Inhale and exhale. Take deep breaths. Inhale and exhale. Take deep breaths. As you inhale, think of the situation that is bothering you, the problems, the challenges, the frustrations, the people. As you exhale, you're letting them all go, fly in the air. I am relaxing now. Repeat after me. I am relaxing now.
I am relaxing now.
I am forgiving everyone.
I'm forgiving everyone.
And I am letting it go.
And I'm letting it go.
Same statements, you start tapping under your armpits, 3 inches under your armpits. You can choose any side. I am relaxing now.
I am relaxing now.
I have forgiven everyone.
I have forgiven everyone.
And I have let it go. Keep tapping, keep breathing. Inhale, exhale. With every inhale, the toxicity goes in. With every exhale, you're releasing your toxicity. And you're emptying yourself. Now the last tap on the head. Start tapping the top of your head. You are empty from top to within. Repeat after me. I am empty from top to within.
It's relaxing.
I am empty from top to bottom.
Empty from top to bottom.
I am relaxing. My body is healing.
It is healing.
My body is healing.
And I'm letting go all the stress, all the frustrations out of me. Take your hand, make it go through your forehead. You can feel the clean and clear space. You can feel the emptiness, the peace, the relaxation that has been restored, that has been restored, that has been restored. Breathe in, breathe out. Close your eyes for 10 seconds. Breathe in, breathe out. Breathe in, breathe out. Now give yourself a number from 0 to 10. Where is your stress right now? Where do you feel you're standing right now? Yes. So how do you feel? What's your number?
Better.
Extremely well, ma'am. Proper relaxed. I think it was badly needed.
That's great. So what was your number before and what was your number after the exercise?
I guess mine was around 8, and now I feel it maybe 3 or 4.
Ali?
6 and 3.
That's great. That's great. Whenever you feel anything is stressing you out or any exam, anything is bothering you in life, if you do this for 2 minutes, 3 minutes, you can do it yourself. It is the emotional freedom technique. Okay, so you can practice it in your daily routine. Okay, so coming back to the course, काफी break मिल गया. आ जाओ भाई, law पे आ जाओ. Okay, Ali, start reading. Case law incorporates.
Incorporate decision made by the judges under both historic legal systems, and the expressions common law is often used to describe all cases law and whatever its historic origin.
Right. I think it's the repetition, nothing to explain. A court's
Yes.
decision.
Decision is expected to be consistent with the previous decision. Can be used to predict the future relationships of the system precedent.
Right. A court's decision is expected to be consistent with previous decisions and to provide an opinion which can be used to direct future relationships. This is the basic of the system of judicial precedent. Okay, hold on to this. Hold on to this. I want you to take a 2 minutes break because now what we are going to start, it's again a little bit heavy. So just relax, take a 2 minutes break, go drink some water, walk around and come back. We'll just start. Right now in my clock it is 12:31. We'll start 12:33. Just 2 minutes break, okay?
Okay.
Yes, so I'm back. Are you guys there?
Yes,
Fam.
ma'am. I'm
The
there.
court's decision is expected to be consistent with previous decisions and to provide an opinion which can be used to direct future relationships. This is the basic of the system of judicial precedent. Who can explain this to me?
The basic system is that what the court does, whatever it's there in the history in the court book. Whenever there's a case, the court just goes through it through and whatever and makes up the decision. And the basic system is the one who has made the decision is the judicial precedent.
Okay. Ali, anything else that you would like to add?
Uh, I sue a person in the case of robbery, and the court like has given a decision. The same case revised after 2 months. So in my case, the guilty person was taken imprisonment in 2 months for 2 months. After 2 months, if the case has repeated, then the decision should be the same that has made in the past uh, in the similar cases. So there should be a consistent like decision on the consistent cases, like the similar likewise cases.
Okay, okay. So you said that the decision has to be consistent, and that's what it's written, that a court's decision is expected to be consistent with previous decisions. That's the first part of the two sentences. A court's decision is expected to be consistent with previous decisions. What do you mean by this? Can you explain it to me through an example?
Consistent.
Consistent with previous decisions. This first part of the sentence.
Like when the first case used to come, whatever the previous decisions they used to make, whatever the regular rules or whatever the regular procedures they used to follow is actually what is happening now.
Ali?
For example, it can also be taken in the way the court has like given someone.
ओके जो बात यहाँ पे समझाना चाह रहे हैं
एग्जाम्पल नहीं आ रही, मैं और कुछ नहीं तो मैंने समझ में आ रहा है.
एक्सप्लेन करना नहीं आ रहा, बात समझ आ रही है, होता है.
Yes, ma'am.
ठीक, इसमें सिंपल सी बात ये है कि मैंने कहा कि भाई चोरी जो करेगा उसके हाथ काट दिए जाए, खत्म बात, लॉ है. जो चोरी करता पकड़ा गया उसके हाथ काट डालो, that's a law. And there is a principle behind this law. What is the principle behind this law? कि चोरी करना जुर्म है, चोरी करना संगीन जुर्म है, तभी इतनी बड़ी सजा है कि हाथ ही काट डालो ताकि इबरत का निशान बने सबके लिए. अब एक केस आया, पहला केस, एक नौजवान चोरी करता पकड़ा गया, कोर्ट ने फैसला सुनाया, कानून ये कहता है हाथ काट दो, हाथ काट दिए गए, हाथ काट दिए गए. दूसरा केस आया, दूसरा केस आया, एक मिडिल एज खातून वो चोरी करती पकड़ी गई, कानून सबके लिए बराबर है, कानून कहते हैं हाथ काट दो, चोरी करता पकड़ा गया, हाथ काट दो, उस खातून के भी हाथ काट दिए गए. तीसरा केस आया जहां पे एक छोटा 5 साल का बच्चा चोरी करता पकड़ा गया, कानून कहते हैं हाथ काट, कानून कहते हैं हाथ काट, चोरी करता पकड़ा गया, हाथ काट. कानून ने नहीं बताया कि ये उम्र होगी, बूढ़ा होगा, जवान होगा, बच्चा होगा, मर्द होगा या फिर औरत होगी, कानून कहते हैं जहां चोरी दिखे हाथ काट. Now, as per the books, as per the rule books, as per the book of law, कोर्ट का फैसला बदलता नहीं. कोर्ट का फैसला जिस प्रिंसिपल के ऊपर रखा गया है, जिस बुनियाद के ऊपर खड़ा है, उस बुनियाद को नहीं बदलती, वो बुनियाद नहीं बदलती और ना बदलेगी. तो कोर्ट का फैसला पहले केस में भी वही होगा, दूसरे केस में भी वही होगा और उसूली तौर पे तीसरे केस में भी वही होना चाहिए. That is what it means. A court's decision is expected to be consistent with previous decisions. बात clear है?
Yes, ma'am.
And to provide an opinion which can be used to direct future relationships. अब उसने फैसला सुना दिए, उसने प्रिंसिपल भी बता दिए और वो साथ में एक एडिशनल ओपिनियन भी दे सकते हैं ताकि फ्यूचर आने वाले जजेस, फ्यूचर आने वाले लॉ मेकर्स को बात और भी समझ आए कि क्यों ऐसा है या क्यों ये फैसला लिया गया या क्यों उसके पीछे ये प्रिंसिपल है और इसकी क्या लॉजिकल अंडरस्टैंडिंग है और यही डिसीजन क्यों हर दफा हर केस में ऐसा ही लिया जाता है. This is the basis of the system of judicial precedent. और इसी पूरे सिस्टम को, इसी पूरे तरीकेकार को क्या कहा जाता है? जुडिशियल प्रेसिडेंट. बात क्लियर है?
Yes, ma'am. It's just like Saudia's rules, I guess.
Okay. Next, अहम पॉइंट, एक ये अहम पॉइंट था. अब इसके बाद एक और अहम पॉइंट. The system of judicial precedent is based on a fundamental feature of English law. इस प्रेसिडेंट के पीछे एक फंडामेंटल फीचर है, एक फंडामेंटल लॉ प्रिंसिपल है. क्या है? That principles of English law do not become inoperative through the lapse of time. बड़ी बात कहती है मैंने. कह रहे हैं कि भाई प्रिंसिपल्स का मतलब समझते हो? प्रिंसिपल्स की वैल्यू क्या है या प्रिंसिपल्स की औकात क्या है या प्रिंसिपल्स का स्टेटस क्या है? ये प्रिंसिपल्स ऐसे हैं कि जितना भी वक्त गुजर जाए, जितना भी जनरेशन गैप आ जाए, जितना भी नया जमाना आ जाए, it will remain operative. You cannot change the law of gravity whether you go 1,000 years back or you go 1,000 years forward. Law of gravity will remain the same. जब तक दुनिया है लॉ ऑफ ग्रेविटी मौजूद है. जब दुनिया खत्म हो जाएगी लॉ ऑफ ग्रेविटी भी खत्म हो जाएगी. So the period of time that has passed, the number of generations that have passed does not matter. The principle will remain intact. That is the importance of principle in an English law system. Getting the point? Make sense? आगे बढ़े?
Yes, ma'am. जी.
Okay. Despite the fact that this chapter is not that long technically compared to other chapters, upcoming chapters, I would like to stop till here because I don't want to rush in. These are completely new terminologies and there are further more new terminologies in this chapter. This chapter is kind of bombarded with so many new things. So I don't want to rush through this chapter. Let's take it bit by bit. I think that's easier to absorb and digest. Okay, I'm in no rush to complete the syllabus. As far as you are in no rush. Okay, so we will try to
Yes, ma'am.
understand everything so that my objective is that whatever concepts I'm giving you in class, you try and memorize and you keep it there in your mind in the class only, so that when you go home you just need to revise, jot down, make the notes. That's it, you're good to go.
Okay.
Okay, so I'll just stop till here.
Yes.
I'll stop till because this concept is like usually the number of batches I have taught, the number of students I have taught they feel that this is bit difficult to grasp. So I will go slow with this concept. Okay, and there are upcoming new terminologies as well. So for today it's enough. Inshallah, we will continue tomorrow and we will complete this chapter tomorrow. Okay,
Okay, ma'am.
fair enough.
Yes.
All right. Ali, any questions? Any queries still here? We are stopping over here and we shall continue from here tomorrow.
Also resend the book because the PDF is not like working fine in my cell phone. The book, the soft copy of the F4.
Okay. Okay. If you share your email ID, we can forward to you at your email. Okay. Just share it in the group so we may do it. Okay. चलो ठीक है जी, आज के लिए यहीं तक। इंशाल्लाह कल मुलाकात होती है। टेक केयर, अल्लाह हाफिज।
Allah Hafiz. Thank you, ma'am.